how to avoid the fourth-headed monster of estate planning and elder law. Oh my, folks, did you know that private pay nursing homes in this area are about $15,000 per month private pay? Today's question, folks, because of that, how do you use an irrevocable Medicaid trust to protect your home from the nursing home? Hey folks, elder law care attorney Patrick Kelleher at elderlawcare.com and the author of How to Avoid the Metaphorical Four-Headed Monster of Estate Planning and Elder Law. Strongly recommend pick up a copy on Amazon, paperback, Kindle, and on Audible. I'll read the book to you. But first, today's question: how do you use an irrevocable trust to slay the metaphorical fourth-headed monster, which is private pay nursing home? Could be as much as $15,000 to $18,000 per month private pay here in the Commonwealth of Massachusetts. And these are numbers folks are given us when we teach our educational workshops and programs in the community. So that being said, folks, you need to look at the actuarial statistical data, because it states that the average period of disability in a nursing home on average is about 3 years. So run the numbers, get your pen out, get your calculator out. $15,000 per month over 3 years or 36 months. What is that number? I'll give it to you. $540,000, folks. So the question is, if either you or your spouse became completely incapacitated, how would you pay for that $15,000 per month private pay nursing home? Or do you have earmarked in your bank account $540,000 to cover that 3-year private pay nursing home coverage or stay for either you or your spouse if either of you became completely incapacitated? And when I ask that question at our educational elder law workshops in the community, I never see a hand go up. But show of hands, how many folks own a home? Go ahead, raise it. Show of hands, how many folks own a home with equity? Raise it nice and high. And when I ask those two questions at the educational elder law workshops, most folks in the room invariably raise their hand. And this is what you need to know around Medicaid rules. Medicaid says the following: you can own a principal residence. Your principal residence is considered a non-countable asset for eligibility purposes for a nursing home. And you can still be house wealthy or house rich and cash not rich, and still potentially receive Medicaid benefits to cover your care in a long-term care skilled nursing facility. The downside, the disadvantage of that approach, folks, if your house is not protected in advance or subsequent to receiving Medicaid benefits, Medicaid is allowed by law to do what? After you pass or your spouse passes in the nursing home, if the home remains unprotected, they can do what? They can put a lien on your property. They call it estate recovery, to be reimbursed dollar for dollar for what they paid in for your care. So if you are like a lot of our clients who are gravely concerned about that, typically folks 65 and over, they want to do the 3 Ps I talk about in my book: protect what you worked hard for, preserve the value of the equity in the property, and then do the 3rd P, pass that on someday as a meaningful legacy, front side of the cloud, to the people you love the most. If you want or desire to do that, folks, it's all about timing, because Medicaid has a look back period of how many years? 5-year look back period, folks, 5 years. Meaning, folks, this is the answer right here. This is the solution. This is the metaphorical sword and shield that will slay that metaphorical four-headed beast if either you or your spouse became completely incapacitated. Number 1, you want to work with your elder law attorney to create what I call an irrevocable Medicaid asset protection trust or treasure chest. That's step 1, folks. However, that red book is not a magic red book. You need to engage with your attorney to transfer your house or deed your home from you, Bill and Mary, as individuals to the trustee of your family's Medicaid trust. Record that deed at the county registry of deeds office. That is getting your treasure, your home or homes, into your treasure chest. And then you do your part. Eat your fruits and vegetables, take the dog for a walk, resume your hobbies, exercise, walk, stay unincapacitated for at least how many years? at least 5 years, folks, because you got to do that future walk, beat out that 5-year look back period. That way, if either you or your spouse became completely incapacitated, then and only then would you be in a position of power and strength to potentially receive Medicaid benefits. Because if you cross the T's and dot the I's with your elder law attorney, your home should be off the table from Mass Health Medicaid. Folks, there you have it. And folks, one last piece of advice here. Make sure your irrevocable trust is considered a grantor trust, so your beneficiary someday get that stepped up date of death value on the property to avoid or reduce capital gains tax. Folks, if you found this video helpful, please scroll down, post a comment or a question, because a member of our elder law care team will get back to you as soon as possible. And folks, if you'd like to learn more, strongly recommend pick up a copy of my book, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, on Amazon. Folks, look forward to seeing you next time at elderlawcare.com.